Table of contents, this file. Part H, the 3 motion for reconsideration mechanisms. Part I, protests on decisions of the BAC, Section 83. Part J, resolution of protests and resort to courts, Section 84 to 85. Part X, dispute resolution, Section 88. This is File 4 of a 5-file guide covering the full contract life cycle under RA No. 12009, File 1, Award, Eligibility, and Commencement, Parts A, B, C, R, T, File 2, Contract Implementation, Money, Time, and Changes, Parts D, V, S, Q, Y, File 3, Completion, Termination, and Warranty, Parts E, F, U, G, W, Z, File 5, Prohibited Acts, Contract Terms, and Reference, Parts K, L, M, N, O, P. Next slide. The 3 motion for reconsideration mechanisms. Motion for reconsideration is not a single remedy, it is 3, each with its own trigger, forum, and deadline. Next slide. Overview. Motion for reconsideration is not a single, generic remedy under RA No. 12009 ZR, it is 3 separate, distinctly triggered mechanisms, each called a request for reconsideration in the actual text. Each mechanism has its own triggering event, filing deadline, and resolution deadline, but they share a broadly similar 3-day to file / 7-day to resolve pattern. Using the wrong mechanism, for example, treating a protest's precondition, mechanism number 1, as if it were the same as a blacklisting reconsideration, mechanism number 3, can cause a party to miss a filing deadline entirely, since the triggering event, not the generic label reconsideration, determines which specific rule, deadline, and forum applies. Next slide. Mechanism number 1, reconsideration of a BAC decision, Section 83. 1. Trigger, any BAC decision at any stage of procurement. Filed with, the BAC itself. Filing window, 3 calendar days from written or verbal notice. Resolution window, 7 calendar days. Special rule, the bidder may not submit additional documents to correct defects in the bid submitted. If a failed bidder signifies intent to file, the BAC keeps that bidder's bid envelopes unopened / sealed until resolution. Next step: if denied, protest to the HOPE, within 7 calendar days of the denial, Section 83. 2. See Part I. Next slide. Mechanism number 2, reconsideration of a HOPE disapproval of award, Section 66. 4. Trigger, HOPE disapproves the BAC's award recommendation, or there is inaction / an explanation of inaction. Filed with, the HOPE. Filing window, 3 calendar days from receipt of the notice of disapproval / explanation. Resolution window, 7 calendar days, with finality. Special rule, does not stay or delay the bidding process, but the award cannot be made until this is resolved. Next step, none specified beyond finality, this is explicitly resolved with finality by the HOPE. Next slide. Mechanism number 3, reconsideration of a blacklisting / suspension decision, Section 104. 1. C. Trigger, HOPE's decision imposing suspension or blacklisting on a bidder / prospective bidder. Filed with, the HOPE. Filing window, 3 calendar days from receipt of the notice of decision. Resolution window, 7 calendar days. Special rule, only one request for reconsideration is allowed. If none is filed, the HOPE's decision becomes final after 7 days from receipt. Next slide. Protests on decisions of the BAC. Legal basis, of RA No. 12009, Section 83. Next slide. The precondition and reconsideration mechanism number 1. This is based on of RA No. 12009, Section 83, opening paragraph and 83. 1. It states, decisions of the BAC in all stages of procurement may be protested to the HOPE, provided that a prior request for reconsideration should have been filed by the party concerned to the BAC and the same has been resolved. 83. 1. The bidder may file a request for reconsideration to the BAC within 3 calendar days upon receipt of written notice or upon verbal notification of the BAC decision. The BAC shall decide on the request for reconsideration within 7 calendar days from receipt thereof. The bidder shall not be allowed to submit additional documents to correct any defects in the bid submitted. If a failed bidder signifies its intent to file a request for reconsideration, the BAC shall keep the bid envelopes of the said failed bidder unopened and/or duly sealed until such time that the request for reconsideration has been resolved. Please take note of this specific rule when reviewing procurement documents. Next slide. Filing the protest, and the fee schedule. This is based on RA No. 12,009, Section 83. 2. It states, in the event that the request for reconsideration is denied, decisions of the BAC may be protested to the HOPE within 7 calendar days from receipt by the party concerned of the resolution of the BAC denying its request for reconsideration. The protest shall be made by electronically filing a verified position paper with the HOPE concerned, accompanied by the payment of a non-refundable protest fee, which shall be paid via electronic payment channels in accordance with the following schedule. This is an important requirement to check during a compliance review. Next slide. Protest fee schedule, Section 83. 2. 50 million and below, 0. 75% of the ABC. More than 50 million to 100 million, 500,000. 00. More than 100 million to 500 million, 0. 5% of the ABC. More than 500 million to 1 billion, 2,500,000. 00. More than 1 billion to 2 billion, 0. 25% of the ABC. More than 2 billion, 5 million. 00. Next slide. Contents of the verified position paper. This is based on RA No. 12,009, Section 83. 3. It states, the verified position paper shall contain the following information: A. Name of the bidder. B. Office address of the bidder. C. Name of project or contract. D. Implementing office or agency or procuring entity. E. Brief statement of facts. F. Issue to be resolved. G. Factual basis and legal arguments in support of the protest. And H. Such other matters and information pertinent and relevant to the proper resolution of the protest. The position paper shall be verified by an affidavit that the affiant has read and understood the contents thereof and that the allegations therein are true and correct based on its personal knowledge or based on authentic records. An unverified position paper shall be considered unsigned, produces no legal effect, and results in the outright dismissal of the protest. Government personnel should follow this provision closely to avoid procedural defects. Next slide. The sworn certifications, and the no-cure rule. This is based on RA No. 12,009, Section 83. 3. Continued. It states, in addition, the bidder shall likewise certify under oath that, A. It has not previously commenced any action or filed any claim involving the same issues in any court, tribunal or quasi-judicial agency and, to the best of its knowledge, no such other action or claim is pending therein. B. If there is such other pending action or claim, the bidder is providing a complete statement of the present status thereof. And C. If it should thereafter learn that the same or similar action or claim has been filed or is pending, he shall report that fact within 5 days therefrom to the HOPE wherein its protest is filed. Failure to comply with the foregoing requirements shall not be curable by mere amendment of the verified position paper. This rule is often a point of focus when verifying compliance with the law. Next slide. Protest documents checklist. Request for reconsideration to the BAC, filed within 3 calendar days, mandatory precondition. BAC's resolution denying the request for reconsideration. Verified position paper containing all 8 required elements, Section 83. 3A to H. Affidavit of verification, attesting personal knowledge/authentic records. Sworn certification of no other pending action on the same issues, or full disclosure if one exists. Proof of electronic payment of the non-refundable protest fee, per the ABC-based schedule. Next slide. Why this matters. The request for reconsideration to the BAC, Mechanism Number 1, Part H, is not optional, Section 83's opening paragraph makes it an explicit precondition to filing a protest. A protest filed without first having gone through, and received a denial from, this reconsideration step is procedurally defective. The protest fee schedule is also non-refundable regardless of outcome. This is a genuine cost of protesting, not a deposit. Next slide. Resolution of protests and resort to courts. Legal basis, of RA No. 12,009, sections 84 to 85. Next slide. The Hope's resolution. This is based on of RA No. 12,009, section 84. 1. It states, the protests shall be resolved strictly on the basis of records of the BAC. The Hope shall resolve the protest within 7 calendar days from receipt thereof. Subject to the provisions of existing laws on the authority of department secretaries and the heads of agencies, branches, constitutional commissions, or instrumentalities of the GOP to approve contracts, the decisions of the Hope concerned shall be final up to the limit of its contract approving authority. With respect to LGUs, the decision of the local chief executive shall be final. The decision of the Hope shall clearly state the factual and legal basis used to resolve the protest and expressly cite relevant portions of the procurement or bidding documents, BAC resolutions, or other relevant documents used as references. Keep this requirement in mind, as it directly affects the validity of the transaction. Next slide. Finality thresholds, national agencies. This is based on of RA No. 12,009, section 84. 2. It states, the decision of the Hope shall be final and executory for the following procurement projects: A. Procurement of goods amounting to 20 million pesos, 20 million. 00, and below. B. Procurement of infrastructure projects amounting to 50 million pesos, 50 million. 00, and below. And C. Procurement of consulting services amounting to 10 million pesos, 10 million. 00, and below. This is a key provision that procurement officers must apply correctly. Next slide. Finality thresholds, LGUs, dramatically lower. This is based on of RA No. 12,009, section 84. 3. It states, in case of LGUs, the decision of the Hope shall be final and executory for the following procurement projects. A. Procurement of goods amounting to 1,250,000 pesos, 1,250,000. 00, and below. B. Procurement of infrastructure projects amounting to 12,500,000 pesos, 12,500,000. 00, and below. And C. Procurement of consulting services amounting to 2,500,000 pesos, 2,500,000. 00, and below. This detail is worth remembering when preparing supporting documents. Next slide. Finality thresholds, critical comparison, national vs. LGU. Goods, 20 million, 1,250,000, 1/16 of national. Infrastructure projects, 50 million, 12,500,000, 1/4 of national. Consulting services, 10 million, 2,500,000, 1/4 of national. Next slide. Why this matters. An LGU procurement is far more likely to exceed its own finality threshold, and therefore be appealable to the regional trial court, at a much lower peso value than an equivalent national agency procurement. This is precisely the kind of threshold confusion worth flagging explicitly. See Part N, Misconceptions. Next slide. Resort to regular courts. This is based on of RA No. 12,009, section 85. It states, court action may be resorted to only after the protests contemplated in this article have been completed. Cases filed in violation of the process specified in article shall be dismissed for lack of jurisdiction. The regional trial court shall have jurisdiction over final decisions of the Hope. Court actions shall be governed by Rule 65 of the 1997 Rules of Civil Procedure, as amended. In cases where the amounts are in excess of the specified thresholds in the the decisions of the Hope shall become final and executory 10 calendar days after receipt of a copy thereof by the parties, unless, within the same period. An appeal to the regional trial court has been perfected. Nothing in this act shall be interpreted to prejudice or prohibit the office of the Ombudsman from exercising its duties, functions, and powers as provided under the 1987 Constitution, R.A. No. 6770, and/or any relevant rules and regulations pursuant thereto. This provision is frequently checked during document review. Next slide. The full escalation chain, consolidated. 1. BAC Decision 2. Request for reconsideration to BAC, 3 days to file/7 to resolve, 3. If denied rightward arrow protest to Hope, 7 days to file, verified position paper plus non-refundable fee, 4. Hope resolution, 7 days, 5. If the amount exceeds the Section 84. 2/84. 3. Threshold rightward arrow appeal to the regional trial court, 10 days to perfect, governed by Rule 65, 6. The Ombudsman's jurisdiction is preserved independently throughout, for any criminal or administrative angle. Next slide. Dispute resolution. Legal basis, of R.A. No. 12009, Rule 17, Section 88, the implementation stage remedy track, distinct from the pre-award protest track in Parts I to J. Next slide. Why this is a separate track from protests. The protest mechanism in Parts I and J, Sections 83 to 85, governs disputes over BAC decisions during the bidding process, eligibility, bid evaluation, post-qualification, and the award recommendation itself. Rule 17 of the titled Settlement of Disputes, with Section 88 titled Dispute Resolution, is organized as a distinct rule from the protest mechanism, Rule 16. Sections 83 to 87, confirming this is meant to address a different stage of the relationship, disagreements arising during contract implementation between the procuring entity and the supplier, contractor, or consultant it has already contracted with. This distinction matters in practice. A losing bidder disputing an award decision follows Parts I to J, a contractor disputing, for example, a procuring entity's computation of liquidated damages, or a denied time extension request, during an ongoing contract is in Section 88 territory instead. Next slide. An important note on the accurate text. Procurement officers and auditors should refer to the applicable Government Procurement Policy Board issuances and the standard bidding documents for the specific procedures on this topic. Next slide. Why this matters for audit practice, even without the full accurate text. A dispute over contract implementation, a disagreement about a variation order valuation, Part 5, a negative slippage computation, Part Q, or a liquidated damages assessment, Part D. 1. Does not automatically become a protest under Sections 83 to 85, because those sections govern BAC decisions, not implementation stage disagreements between already contracted parties. The Ombudsman's independent jurisdiction, already noted in Part J. 4, for the protest track is preserved the same way here. Dispute resolution or arbitration under Section 88 does not foreclose a separate criminal or administrative angle if the underlying facts warrant it. For audit purposes, the practical takeaway is procedural. Confirm whether a given implementation stage disagreement was actually routed through the correct mechanism. Section 88 dispute resolution/arbitration, rather than being treated informally as a unilateral procuring entity determination with no documented dispute process at all. Next slide. Audit observations, dispute resolution. 1. An implementation stage disagreement, e.g. over a variation order valuation or a liquidated damages computation, resolved unilaterally by the procuring entity without any documented dispute resolution process. Arbitration clause invocation, or amicable settlement attempt on file. 2. A Section 88 dispute mistakenly filed and processed as if it were a Section 83 protest, or vice versa, applying the wrong forum, deadline, and procedural rule to the wrong stage of the relationship. 3. Contract implementation halted by a contractor pending dispute resolution, without documentation of whether continued performance was actually required pending resolution under the applicable rule. Next slide. Deadlines, delays, and technicalities. Every remedy in this file lives or dies by a short, calendar day window, and by which of 3 reconsideration mechanisms actually applies. Next slide. Missed 3-day filing windows across all 3 reconsideration mechanisms. All 3 motion for reconsideration mechanisms in Part H share the same 3 calendar day filing window from receipt of the relevant notice. These are calendar days, not working days. A window that closes on a weekend or holiday still closes on schedule. A request filed even 1 day late, under any of the 3 mechanisms, is technically out of time regardless of the underlying merits. Next slide. Missed 7-day protest filing window. Section 83. 2 gives a party 7 calendar days from receipt of the BAC's denial of its request for reconsideration to file a protest with the hope, accompanied by the non-refundable protest fee. Because the underlying reconsideration is itself a mandatory precondition. Missing this second window after already clearing the first one is a particularly costly technical failure. The earlier effort is wasted along with the later one. Next slide. Delayed hope resolution of a protest. Section 84. 1 gives the hope 7 calendar days to resolve a protest, strictly on the BAC's own records. A delayed resolution does not just create administrative lag. It delays the 10-day window under Section 85 within which an aggrieved party must perfect an appeal to the regional trial court once the applicable finality threshold is exceeded, compressing the effective time available for that next step. Next slide. Missed 10-day window to perfect an RDC appeal. Under Section 85, once a hope decision on a protest exceeds the applicable finality threshold, Section 84. 2 National/Section 84. 3 LGU, the decision becomes final and executory 10 calendar days after receipt unless an appeal to the regional trial court has been perfected within that same window. This is an unforgiving deadline. Once it lapses, the decision is final regardless of how strong the underlying case for appeal might have been. Next slide. Only 1 reconsideration request allowed in a blacklisting case. Section 104. 1. C. S. Only 1 request for reconsideration rule, Part H, Mechanism Number 3, is a hard technicality worth flagging on its own. Entertaining a second reconsideration request in a blacklisting or suspension case, even out of an abundance of procedural fairness, is itself a departure from the express text. Not a generous accommodation. Next slide. Misconceptions. 10 commonly held but legally inaccurate beliefs about reconsideration, protests, and dispute resolution. Next slide. On there being 1 reconsideration process. A common misconception is this: there is 1 motion for reconsideration process that applies across all of procurement. The correct rule is as follows: there are 3 separate mechanisms, for a BAC decision, for a hope disapproval of award, and for a blacklisting/suspension decision. Each with its own trigger, forum, and deadline, Part H. Next slide. On skipping the BAC reconsideration step. A common misconception is this: a losing bidder can file a protest directly with the hope without first going through the BAC. The correct rule is as follows: Section 83's opening paragraph makes a prior request for reconsideration to the BAC, and its resolution an express precondition to filing a protest. Skipping this step makes the protest itself procedurally defective. Next slide. On the protest fee being refundable. A common misconception is this: the protest fee is refunded if the protest ultimately succeeds. The correct rule is as follows: Section 83. 2 describes it as a non-refundable fee, paid at the time of filing. Refundability is not conditioned on the outcome. Next slide. On curing an unverified position paper. A common misconception is this: if a position paper is filed without the required verification affidavit, it can simply be amended afterward to fix the defect. The correct rule is as follows: Section 83. 3 states this failure is not curable by mere amendment. An unverified position paper is considered unsigned, produces no legal effect, and results in outright dismissal. Next slide. On appealing to the office of the President. A common misconception is this: a losing bidder dissatisfied with a hope's protest decision can escalate all the way to the office of the President. The correct rule is as follows: no such appeal exists in the ERS chain. The actual escalation path is BAC reconsideration rightward arrow protest to the Hope rightward arrow regional trial court, once the applicable finality threshold is exceeded. Next slide. On national and LGU finality thresholds being the same. A common misconception is this: the PESO thresholds that determine whether a Hope's protest decision is final and executory are the same for LGUs and national agencies. The correct rule is as follows: they are dramatically different. An LGU's goods procurement decision is final only up to 1,250,000. 1/16 of the 20 million threshold for national agencies, per sections 84.2 and 84.3. Next slide. On filing a protest automatically pausing procurement. A common misconception is this: filing a protest automatically suspends or pauses the ongoing procurement activity until it is resolved. The correct rule is as follows: 66.4, which states plainly that reconsideration does not stay or delay the bidding process. Next slide. On protests and dispute resolution being the same remedy. A common misconception is this: the protest mechanism, sections 83 to 85, and dispute resolution, section 88, are just two names for the same remedy at different points in the process. The correct rule is as follows: they are organized as distinct rules governing distinct stages. Protests address BAC decisions during bidding. Dispute resolution addresses disagreements arising during contract implementation between already contracted parties. Next slide. On the Ombudsman's jurisdiction being displaced. A common misconception is this: once a protest is filed and pending with the Hope, the Office of the Ombudsman cannot separately get involved in the same underlying facts. The correct rule is as follows: the Ombudsman's independent constitutional and statutory jurisdiction is preserved throughout the protest process. Pursuing a procurement protest does not foreclose a separate criminal or administrative angle. Next slide. On repeated reconsideration requests in a blacklisting case. A common misconception is this: a blacklisted bidder can keep filing reconsideration requests until one is finally granted. The correct rule is as follows: Section 104.1c allows only one request for reconsideration in a blacklisting or suspension case, if none is filed within the window, or after the single request is resolved. The decision becomes final. Next slide. Audit observations. 20 recurring compliance gaps in reconsideration, protests, resolution, and dispute resolution. Next slide. Reconsideration mechanisms. 1. Protest accepted by the Hope without confirming a prior BAC reconsideration was actually filed and resolved, the Section 83 precondition. 2. Reconsideration mechanism number 1, BAC decision, filed beyond its 3 calendar day window still entertained by the BAC. 3. Mechanism number 2, Hope disapproval of award, and mechanism number 1, BAC decision, treated interchangeably, applying the wrong forum or deadline to the wrong triggering event. 4. Mechanism number 3, blacklisting/suspension reconsideration, entertained more than once for the same decision, contrary to the explicit only one rule. 5. Failed bidders' bid envelopes not kept sealed pending resolution of a reconsideration mechanism number 1 request, contrary to Section 83. 1. 6. Additional documents accepted from a bidder to cure defects in its bid during a reconsideration mechanism number 1 proceeding, contrary to the explicit prohibition in Section 83. 1. 7. Hope's 7-day resolution of a reconsideration mechanism number 2 request exceeded without documented reason. Next slide. Protests and their contents. 8. Protest filed beyond the 7 calendar day window from the BAC's denial still entertained by the Hope. 9. Verified position paper accepted despite missing one or more of the 8 required elements under Section 83. 3. 10. Position paper accepted despite lacking the required verification affidavit, contrary to the explicit no-cure rule. 11. Sworn certification of no other pending action on the same issues missing or incomplete. 12. Protest fee not collected, or collected at the wrong tier of the ABC-based schedule under Section 83. 2. 13. Hope's protest resolution issued beyond the 7 calendar day window under Section 84. 1. Without documented justification. 14. Hope resolution silent on the factual and legal basis the resolution is required to state under Section 84. 1. Next slide. Resolution, courts, and dispute resolution. 15. National vs. LGU finality thresholds confused, resulting in an incorrect determination of whether a decision was actually appealable to the regional trial court. 16. RDC appeal not perfected within the 10 calendar day window despite the decision exceeding the applicable finality threshold. 17. A Rule 65 petition filed without first completing the Section 83 protest process, risking dismissal for lack of jurisdiction under Section 85. 18. An implementation stage disagreement resolved unilaterally by the procuring entity with no documented Section 88 dispute resolution process on file. 19. A Section 88 implementation stage dispute mistakenly filed and processed as if it were a Section 83 pre-award protest. 20. A prima facie corrupt or collusive circumstance surfaced during a protest without a corresponding ombudsman referral being considered. Next slide. End of disputes, protests, and reconsideration. Every quotation in this file is drawn directly from the text of the implementing rules and regulations of Republic Act No. 12,009, cross-checked section by section, except where a slide explicitly flags an important note. Part 10. Award, eligibility, and commencement, contract implementation, money, time, and changes, completion, termination, and warranty, and prohibited acts, contract terms. And reference continue. This references coverage of the remaining stages of the contract life cycle. This concludes this audio guide. Thank you for listening. Table of contents. This